right, on the record on page 24 starts the cases that are on calendar, report motions, Oren and Alon Alexander, and Ohad Fisherman. If the state wants to put their names on the record as well as the defense.
That was neither a law coming up the state.
And good morning, Your Honor. Juan Michelin and Jeff Sloman on behalf of Mr. Fisherman. I did see Mr. De Niro walking in right now.
He's here.
Good morning, Judge.
Morning, and I see Mr. O'Donnell is also on Zoom, and Ms. Peebles is also on Zoom.
Yeah, good morning, Your Honor.
Morning, Your Honor. Yes, I'm out of town, so I'm appearing by Zoom.
Let me do this first. I think BC may be with that. She might be that number down there.
I'm here. Brittany's here.
All right, so let me just get an update. Well, why don't you tell me, did you and the defense come to an agreement?
I called the defense's people who they wanted me to contact for the phone. And they did not know that I was going to be contacting them. So they are trying to set up a meeting with me.
Okay. So it looks like you had enough time to think about it, review the documents as well as subpoena, and you're gonna go through with the court's order.
Correct.
Thank you. Let me just get an update from the defense.
So, Your Honor, as far as update from our end, we did hear that DC did contact our expert but there was no extraction date scheduled. We would just ask if Your Honor would instruct her to do that in the next
All right, so
day
maybe
or two.
it's gotta be done this week. We're scheduled for trial on Monday, so it has to be done this week. So I would I'm asking that you please coordinate a day this week so that can be done.
And Your Honor, we would just ask, for it to be by Wednesday so that they could have time to do the actual extraction and get it back to us.
They're asking by Wednesday. I think that's reasonable. Okay, BC?
Yes, they were supposed to call me back and setting up a date with me. So I'm just waiting for them to call me back.
Judge, I think the issue, I spoke to BC last week and she gave me this update. I think the concern is the company didn't know anything about her. They didn't know why she was calling. So I think we've settled that at this point. But I think, as of Friday, she is actively trying. If this company can't do it, that's a different issue.
I don't know, but did anyone say they can do it? Did they say they can do it?
No, I think they didn't know anything about her. So I don't know if you guys have.
They're aware.
Okay, so hopefully they can get it done.
Thank you for your cooperation. Can I excuse her?
Yes, Your Honor.
Okay, you're excused for the day. Thank you.
Am I done?
Yeah, you're done. You're done with me. Thank you.
Okay, thank you so much.
All right. What is so that one was the easier motion to dispose of. Is there another one that's similar that we can dispose of? I'm thinking maybe the issue with KW and her that she may have to turn off the phone.
I saw Ms. Peebles online. I know she represents her for that purpose.
You have the motion in Peebles that KW may have gone. I'm sorry, that KW did go submit her phone for the extraction, but the expert could not. They think she may have some sort of software that prohibits that.
Yeah, and look, there's a couple things here. I saw the motion that was filed on Friday. One of the things is they were able to extract her phone data. This MDM software that they talk about, I believe, is it's something to do with employers have it on there for like 2-point authentication types of situations and other things. There's no program my client was aware of that was impeding that, and they were able to extract the data. And I believe even in their report that they filed that they indicated, she said, look, there was a period of time within which she didn't get stuff backed up that's not there. That's includes, I think, several months. So I don't see why another extraction would do anything different than it's done, because they did get data from other points and times. And another concern is that this was supposed to be a neutral third party entity performing this. And they've not provided my office with any of this information, and we've had direct contact with them. And if there was issues with getting the extraction done during that time, they had our phone numbers, and they never indicated there was any problems. I understand that she had to come over a few times and have her face, put her face up so that would pass that. But my understanding was they were able to extract data.
So, may I respond, Your Honor? So just to be clear for the record, we do not have anything from them. So the only thing we have is the report that we filed as an exhibit with the 3 screenshots. They have not, because of Your Honor's court orders, not turned anything over. There is, for the window that Your Honor ordered them to filter through, right? There is nothing in that window. And what the report basically says is there is MDM software on it, and either the MDM software is preventing a successful complete extraction, and therefore that, for whatever reason, that date range came back empty, or KW completely wiped that portion of her phone, one or the other, right? So the only way to know for sure would be if KW would remove the software and allow for another extraction to confirm why every single range that Your Honor set is completely empty.
What you didn't get, from the company, if there is anything of value that they extracted?
Well, I guess, Your Honor, it depends on how we define a value. Within that range that Your Honor set, no, which is why within the criteria Your Honor set, no, that's why we don't have anything.
Stop.
So they're, and according to the report, and again, all I really know is what came from the report is it could be either. It could be either the MDM prevented a complete successful extraction, or she just wiped that entire portion of her phone. If we want to operate under the assumption that the MDM did not prevent a successful extraction, as Ms. Peebles suggests, then her client wiped her phone. So, you got to choose which one you want to go with. I have not seen, to be clear, I have not seen anything from her phone other than these exhibits and this report, which just the report that I filed as an exhibit, and then
But you can get it.
I got these, which we also attached, which just show for the date range of 12:30 to 1:1. There's nothing. I don't know what Ms. Peebles is referring to is up here where it says timeline. It says 29,993 items. We haven't seen them. We just know that number exists, which again suggests then, what are the odds that there's nothing during that date range, but the phone did have almost 30,000 items in the timeline, which again just suggests that there's no, that she either wiped it, right? We received this other screenshot, Your Honor, that I attached. And again, you can see it's not zero, right? There's images, there's videos, but we didn't receive any of that, to be very clear. We don't have any of that, but it just shows were able to do a full, at least they were able to pull from the phone. There's nothing for the criteria Your Honor set. And
you asked about her phone in that day range. She said that she lost everything for a 2-year period. She didn't back up. But she didn't think she had anything from that period. So I'm gonna put that in. Maybe saying you were white. It could also very well be that back up.
Right. So Your Honor,
And if I could address
here's the issue. It's impossible. And this is what makes it concerning, right? And obstructive, because it is impossible to have a phone and not know you have that software on, whether she put it on herself or, as Ms. Peebles, I guess, seems to be suggesting that it was her employer. One or the other. There's no way you're walking around with a phone not knowing you have this application, this software on your phone, and yet she didn't tell anybody, right? So our expert shows up, tries to do an extraction, comes back with chunks of wiped data. If it either was an innocent mistake and the software's preventing it, and then we need to do it again so we can get relevant data, or Ms. Peebles' client wiped her phone.
Yes.
Your Honor, just say the relevant period is from 2016, which we're all aware of. The options are not only that she wiped her phone or this program's preventing data. That's just not it. Most people don't have messages from 2016 on their phone. My understanding is she testified during her deposition before there was any extractions or all of this, that she didn't have anything she could find on her phone from that time period, that one of her phones didn't back up or along those lines. But to say that something's been wiped is just, it's inaccurate and completely not consistent with what her testimony's been and what is on most people's phones. Not everybody has messages from 2016. That's a significant time before that. And so to suggest she wiped her phone is that. Now they're saying this, if this program prevented, they're saying it prevented anything from downloading. She was there to use her face to unlock whatever, and they were able to get items. Now they're saying 29,000 because they downloaded her entire phone from the beginning of time until today. So 29,000 items could be what she's had is on there. That's not an indication of anything being wiped. And it's also indicative of the fact that they were able to extract information. And it's consistent with the fact that her phone didn't back up for, I believe, a couple years, several months.
So, Your Honor,
not just this limited time frame.
Right, I can appreciate cases 8 years old. We all know, complain, we have to get new phones every few years, right? We get that. So at this stage, I can appreciate the argument. She has a new phone and perhaps when she got the new phone, whatever was on the old phone from 2016 didn't transfer over.
but Judge,
I can appreciate that. The issue is, if she has this software on her phone, it should have been removed before the extraction.
so, and Your Honor, I want to clarify one thing, because this is how we know that at best, Ms. Peebles is just innocently mistaken. We were here about 3 weeks ago because Ms. Peebles filed a motion because she did not want us to see an unredacted copy or version of a video taken that weekend, a video that Ms. Peebles claimed was on her client's phone. And it was a big concern because that video was from 12/31/16, right? 12/31/16, and she did not want us to see an unredacted version of that sensitive content video. And Your Honor issued the order. So that video did not generate a hit. That wasn't even found. And that's from that weekend. And Ms. Peebles was in this courtroom arguing that she wanted us to not see it because it was on her client's phone. So, right.
They couldn't, it states.
And it's from 12/31 at 7:30 p.m. And it's of KW. She's in it. So where's that? If it was simply that there's no, there was no wiping or whatever, then that the experts should have found that video and they didn't. So that just goes to show that it's not as simple as it could be a third option and people just delete their phones and they get new phones. No, because Ms. Peebles was in here saying, don't look at that video from 12/31/16. And yet when they look at the phone, it's not even there.
And even Your Honor, Joel Panera for Alon Alexander, even more concerning is we now know that there was a WhatsApp joint chat between these four ladies, and it's not appearing on any of the phones. So what are the chances that all four of them would have a group chat? They'd be communicating, passing the video that we just discussed within that group chat, and none of them would still have the group chat remaining on their telephone. So that's why we need full access to their phones, Your Honor. And we asked Katie in deposition, who put the software on your telephone, and she refused to answer. So it's just, well, no.
She testified at the door. Yeah, so that's a reasonable.
Right, okay. Judge, we have, it's just, what we're seeing, Judge, is this pattern of making things very difficult from us, starting with the state, when all of these witnesses are care of the state. And Your Honor grants a motion to let us allow a limited extraction of their telephones, and then they become not care of the state. So it's delaying things. There's a group chat that we now know was on all 4 of their phones, which today is missing. So yeah, and I would just ask Ms. Peebles, who put the software on KW's phone? Is it she's saying that it was work related? Is she saying that the work plays the software on her private phone?
State's saying that's what KW testified to like that. No,
You have page it up.
on the point that this is a neutral third party, Ms. Peebles would like to communicate with them.
Ms.
Try to diligence.
Your Honor, that's interesting. Interesting, she brought that up. We ended up finding out that apparently Morgan and Ms. Peebles, and I don't want to say necessarily Ms. Peebles because I can't for sure say it was her, but at least someone from Morgan, during that window, I just want to remind Your Honor, the initial order Your Honor granted was from, I believe, May 15th. And then Ms. Peebles, on behalf of her clients, started filing motions to quash. We end up finding out when we're discussing this whole report with the expert that he was very confused because apparently he had been getting contacted by Morgan from as early as back when they were filing motions to quash. They were also talking to this expert when we were not, because we were trying to maintain a distance to not make it seem like there was any kind of impropriety going on. So he ends up meeting us, and you wouldn't believe he thought we worked for Morgan. He thought Morgan was initially the ones hiring him. So I'm sure nothing has stopped Ms. Peebles from communicating with our experts. And we don't really, they're defense experts. It's not that easy if she wants to talk to our experts, she can depose them, right? Because I can't call whoever did the MBPD extractions and just get on the phone with them. The state would not let that happen. I would have to come here, ask for a second deposition, and it would take forever to get them. So if she wants to talk to our experts, she can find a way to set the deposition.
Sounds like both sides, meaning your side and the defense people, if the expert's going to communicate with you, it has to be with the other side of the person. What are your thoughts on that?
The communication was with staff from my office to facilitate setting up this extraction and to get the details of what they could do and if they were able to go to her place and get that, which is what the subpoena directed it to do. They were not disclosed as an actual retained expert, an expert maybe for the purposes of saying, hey, this is what I did and that, but there's a difference between I'm kind of a neutral party here, I'm just doing the extraction and I'll tell you what the data has, versus I'm going to be independently hired to analyze and do other things for the defendant. But the subpoena had direct.
I don't know how.
It sounds like we're playing telephone with this company. So Ms. Peebles, I'm going to allow you access to them because they are deemed by this court as a neutral third party. But so we don't have this problem of, well, they said this and this is our impression. If you're going to talk to them, have the defense on the other line, so that we avoid any miscommunications in the future. Okay.
Your Honor, I would ask if we're going to do that. Relatedly, we don't even know the name of the person from MBPD that did CW's and MW's phone extractions. So we would like to know from the state the name of who that expert is and whether we could similarly have similar access to that person before trial.
They had time.
Who is it?
So
We don't know who it is. Who knows? Because the extraction says Albert.
You, when can she try this Monday? She's gonna have to submit her phone. I already did it for BC between now and Wednesday with the software removed.
She's KW is currently in France.
Okay.
Travel overseas,
When does she get back?
when did she get back?
She's there for I believe until September. I think she was going to make herself available to come back for trial, but she's had a long planned trip and she's currently in France.
That is
Is she now?
What an amazing plot twist.
It's September.
No, but she'll come back and try it, is that your understanding?
That's my understanding.
State, realize how they're play out.
So you're done. I would like to.
Hold on, this people's in the state, realize how this may play out in cross examine.
I mean, I don't know what to do, Judge, as far as from the state's perspective.
Well, Your Honor, in terms of, I want to remind the court how she was originally care of the state and now she's not. We would ask, she now has to be care of the state if we want to subpoena her for trial, because how are we going to subpoena her in France?
She will be here for trial.
Well, we need to make sure. Sorry, Judge.
Right, so the motion is to compel her to submit her phone for another extraction, that the software is granted. You all will coordinate when she's back in town for trial, when she's going to do that. Ray, you have this motion? All right,
She's on the line.
all right, defense motion to expand prior order. I have that as my. Next motion of.
Judge, the defense needs more access to the telephones. When we were taking the deposition of MW's, I guess, ex-boyfriend, current boyfriend, paramour, we're not exactly sure at this point, but we know from his deposition that there's still an ongoing relationship between MW and Nelson's last name is Cardenas. So we took his deposition, Your Honor, and in his deposition, Nelson said that he was asked by MW to help, or that she was, quote unquote, building her case, and she needed him to be a witness to buttress her testimony. So we'll assume that the state is relying on him to be a rebuttal witness, perhaps. And we know that what he said is true, and we know that she was using him to build his case because we found out through the limited extractions that we have that MW and her sisters were texting each other, trying to figure out what hotel they were staying at. This came out in deposition. So in deposition, we find out that in the extractions, we find out that in around 2024, in that limited time period that you allowed us to take a look, it was June of 2024, that MW is asking her sister, hey, first of all, what year? She didn't even know the year that they were in Miami that this alleged rape took place. That's the first thing. So they're trying to figure out when it was. And then she asks her sister, what hotel did we stay at? Now, if the court remembers, this would have been the hotel where MW comes back and is hysterical and recounting this horrible event that took place in her life just moments or 10 or 20 minutes prior. So we think that this would be obviously a place that she would never forget. And the fact that she, according to Nelson, needs help trying to build her case, we know in that limited time period that they're trying to find out extremely important details about the time and the place where these events took place. So we think that if we were given access to her phones for the subsequent months, we would find more very important information that would show us what they were doing to try to build, or as we think, manufacture this case. But June is just one sort of arbitrary month. I think it was a sort of a starting place that the court gave us. And now we know that there's real action going on between MW and her sisters as to try to recount what was taking place. And obviously memory.
We let you go to MW's phone for June 2024.
Right. So we let, so, right. We do.
So they are talking about the roads. You have some of this impeachment and George, they are. They're discussing lawyers.
We judge it kept and continued. What we have is we have Nelson in deposition, but just one example, Judge, why we need to see her communications with Nelson is in deposition. He says that he never, ever deleted any of his text messages. So we want to find out the nature of the relationship. We want to find out if they're still intimate. I believe that my personal feeling is that they are. So we asked him, listen, do you mind if we take a look at some of your messages with MW? Of course, he said no. So at a bare minimum, Judge, we have to see what her text messages between a witness in the case who's going to buttress her testimony is, especially when they're having a romantic relationship. So we just need to see it, Judge, and it's no prejudice to the witnesses. It's no prejudice to the state. Judge, this is stuff that they should want us to see. We should not be going through a charade, making it so difficult to get access to their phones, Judge. We shouldn't be having a situation where they're hiding behind attorney-client privilege, which is the basis of our next motion, when it's so clear, Judge, that the attorney-client privilege was waived, and I'll blend into that, Judge. Just Ms. Peebles says, well, they never waived the attorney-client privilege, and Your Honor goes, well, I'm going to take you at your word. And we go into deposition, and sure enough, we find out that MW gave Ms. Peebles permission to share her story with the state. And we know that happened in front of Judge Alvarez, in front of Officer Alvarez, where she's sharing her rendition and a clear waiver of the attorney-client privilege. So what we've seen is them trying to hide evidence to us in the face of very, very serious allegations, Judge. And we need to see more. And go ahead.
Judge, just one last point on that. Your Honor, as you pointed out, gave us June, and in just that 1 30-day period, there was a lot of communication about the case between the sisters, et cetera. Like Mr. De Niro said, right, exactly, and that because that's when CW sent the Real Deal article to MW, and that's when everything kind of got started. Now that we can confirm that it wasn't just that exchange, but there were more exchanges the rest of the month. There's really no reason to believe that those exchanges did not continue going up until present time. There's no reason to assume that there is no relevant data in July, in August, and September, and October, et cetera. June, in my mind, was I guess an initial month that confirmed these people really are having these conversations. Up until that's the issue, Your Honor. No,
But they've already. You've been able to extract some of this impeachment testimony that you want, right?
right, but a lot of it, was not disclosed to us. No one ever told us that they didn't know that what year this allegedly happened.
You said that, well, that happened 8 years ago, right? I know that you may believe that they're lying, but at the same time, it is an incident that was from 8 years ago.
It's not just that.
You can use it however you wish.
Right.
It's out in trial, right? Nobody knows how it's gonna come out in trial, but I just can't see fading in memory
But it's
or lying for me to let you have the information, have the material.
it's not just that, Your Honor. You're right. Someone could it was 8 years ago, fine. But the issue is, when they all walked in, they all were pretty confident about what hotel they stayed at. They were all pretty confident. It is on the record. Everybody had an answer, had a hotel name. So what and I'm sure Your Honor, I think Your Honor saw it. Like MW asks CW, what hotel were we staying at? And CW responds, I don't know. And yet somehow MW and CW both walked into depositions with hotel names ready to give. So we have no idea what else was manufactured over the next few months going forward. The question isn't, it's just relevant evidence. It's just, is it relevant? And that's a low bar. And
But spin on what you all believe at this point is a coordination of testimony, right?
and there's
But you probably already have it to make it.
we have some of it, but we don't know what we don't have. And there may be something else that's even more relevant than anything else we've seen. So there's just really, especially from MW, right? Especially from MW, there's more. There has to be more. And the question is not how far are we going to go? The question is there likely to be relevant evidence from July? For sure. Is there likely to be relevant evidence, for example, leading up to the interview with Alvarez in October? 100%. Is there likely to be relevant evidence after we began our depositions in mid or late April? When these are the same witnesses, Your Honor, who every single one of them would come into deposition and we would ask them, somebody would ask them, Mr. O'Donnell, De Niro, someone would say, have you spoken to your sisters about this? Have you spoken to BC about this? And everybody, as if they had coordinated the response, was like, no way, we would never, we can't do that. And we're like, who told you can't do that? Because I don't know anybody who told you, oh no, we just assumed we couldn't do that. Well, of course we're not talking to each other. Then we find out not only that they're spending, obviously, like they're sleeping at each other's houses now and spending time together, but clearly they were talking to each other at least in June. So they were lying about talking to each other in June, in July. In July? There's nothing to suggest that the relevance did not increase as the months got closer to October and then to now, right? Because if there is, I have zero doubt in my mind that there are going to be conversations between them about don't show your phones, don't do the, talking about depositions, talking about testimony, talking about questions we asked them. It's abundantly clear given the little bit we found in just a month from just one phone, right? So imagine it's just clear that there is more relevant evidence in the future months.
I would just add during Nelson's deposition, it came out he said he was asked by MW in deposition, what happens if they look at your phone? So that was the first red flag. She was worried that we might get a hold of Nelson's phone. And then Nelson says in deposition that she wanted to meet in person to discuss the case, not by text. So we really need to see the communications between state's witness who they just listed a month ago, and her boyfriend, or they've had a relationship, it looks for many, many years. And we just have to see the communications. There's just no prejudice to the state. And can you imagine, Your Honor, if after this trial and after these trials are over, we learned something that was on those phones that could have exonerated. So any harm in allowing us to see the communications where it's clear that there's a coordination.
All right, Ms. Peebles, you represent MW and KW, right? CW as well?
Correct.
So
Yes.
defense wants me to allow further extraction of their phones from after June of 2024 for messages between all three.
Look, I don't know when this motion was filed or if I was ever noticed on that, or if this is, I don't know if this is just something being brought up, but
It looks like it was filed June 19th. They may not have remembered that you represented them on the motion.
But I believe the state immediately responded and copied her on.
Doesn't look like they're gonna have a response from me today.
well, look, I would just ask that if I could also have time to maybe put forth a written response after today, but I would say this, look, they've already gotten so much from their phones. I'll start with my client MW. Obviously, she's the victim here, but she doesn't open up her entire personal life to defense in this case. Private conversations she's had with her sisters, most of which probably is not about this case at all, is just it's an invasion of privacy going beyond anything else. There's not this coordination, and someone who she dated several years ago and has remained friends with, to get their communications about anything is really just, it's not relevant.
Your Honor, here's the issue. I think we can make this a lot simpler. First of all, I don't think Ms. Peebles is in a position, once again, as she has been throughout the case, to determine relevance. But given the time constraints, Your Honor, perhaps this is the easiest, fairest way to do it. Your Honor can order and look at it in chambers. And then you let us know, Judge, if I am 100% sure you will find relevant information. And then Ms. Peoples has no say because she's not part of the criminal case, right? Her client's privacy rights do not extend to the point where they can affect people's due process rights and put them in prison. So that's not how it works. But Your Honor does have the power as a judge. You can expand the order. They would not have to do another extraction. The Miami Beach PD, it's not even our expert, their expert. The police department already has the extractions. There is absolutely no harm in Your Honor expanding the order and ordering that Your Honor can see it in chambers. And then if you find anything relevant, you can let us know.
And Judge, just as to Nelson, I know she's saying that they're friends. Well, yeah, I think that they are friends, Your Honor, but it's like they have an intimate friendship just based by so if the court were to review their messages, which we already have, we just have to hand them over to Your Honor, the state has them. And then you can see if they're having an ongoing romantic relationship during these times, I think it's clearly relevant. And it seems from the deposition that it's clear that they are. And so we need to understand the real true nature of their relationship. And he has the text messages on his phone. Therefore, she has them on her phone and he won't share them with us. So we really need to see him if the state plans to call him as a witness or
I'm not inclined to grant this. I think you all, it's obvious from what the way that I'm asking questions, I'm having a hard time convincing myself that it's not just taking its position at this point. And I've already given you all pretty specific points in time that relate back either to the allegations or that June month, when the civil lawsuit was filed. At this point, ongoing conversations between these women who are sisters is going to happen, right? They've been subject to deposition. So but I'll let Ms. Peoples respond, and it looks like we're back together on Wednesday, right? So should I pencil this in for Wednesday, the motion to expand prior order?
Sure. And as to Nelson, Jeff, you would find the same thing when they are
Here on Nelson.
well, Jeff, we don't ever get any responses from anyone.
So you want Nelson's?
Yes, or Tennessee asking.
Expand this. From NW's side, there'll be messages between her and Nelson, right?
Nelson says that he's never deleted anything, so unless she did, they'll be there and we'll be able to see what the nature of their relationship is. Somebody the state intends to call as a witness to buttress her testimony. So if they're having an ongoing romantic relationship, as it appeared they are, we think we should be able to discuss that to the jury and explore that. And I don't see the prejudice if Your Honor's looking at it first.
Your Honor, may I just be very, very briefly? To just emphasize Mr. Michelin's point with regard to the ongoing conversations with the sisters. On October 24th, for example, 2024, so MW's sworn statement was taken October 8th. And in her sworn statement, she mentioned KW, CW, and BC, right? So with that, Detective Alvarez tried to make arrangements to speak to KW, BC, and CW. He spoke to CW first, okay? But he had trouble getting in touch with KW and BC. And so we have from chapter 119, may I show it to Your Honor? On October 24th, this is from Ms. Snyder to Chris Peoples, where Ms. Snyder asks Ms. Peoples to nudge them. So by this time, by October 24th, the sworn statement takes place on October 8th. 16 days later, he still can't get in touch with them. It may be a coincidence, it may not be, but it was such a concern because Ms. Snyder then asked Ms. Peoples to nudge them. And it's, to pick up on Mr. Michelin's point, it's, I think, beyond a certainty that there were conversations going on between those two and MW concerning what they were going to say. We suspect that an expansion of this order will reveal that. It's beyond relevant, it's extremely material, and we believe would serve as impeachment to those witnesses.
Correct. So we'll revisit it on the fourth. Right. That's how it's going to go.
I won't.
Count number one, so you know. Be careful. Okay, so state, we have a motion to start the testing, right? Yes, I did see it, or respond.
Your Honor, if I may, first, they blanket list the state's witnesses, which is not permitted under the rules. So I ask that you strike that for that particular reason. The second issue is they've listed me as a witness regarding the March 19th, 2025 conversation. Judge, the victim has testified to that conversation in deposition. She can be impeached with her deposition. If it gets to a point where my conversation with her becomes important in the trial, I would be willing to stipulate to what's in the discovery exhibit. But I don't think that calling the ASA as a witness is warranted in this situation, and my response lays out why.
For paragraph 4. Just want to get out all the witnesses. The listing not specific. When it comes to reading,
We can do that if Your Honor wants, yes,
it's
not a problem.
they can put them on notice, they can go on notice at this appointment or document, so let's go ahead and just list them specifically.
We'll do, Judge.
What about the stipulation regarding Ms. Snyder and MW testifies inconsistently with what she's already testified to? Right, she already testified that she did give over additional statements to Ms. Snyder.
Kind of. She's testified first she denied it, then she said she wasn't sure, then she said maybe. She's equivocated multiple times in the same deposition. So given the concern that she may deny it and we may need to impeach her. Well,
Yes, I will enter into a written stipulation regarding what the discovery exhibit says. I forget what the exact date of the discovery exhibit, but from that date, if that becomes necessary, I don't, what she says on the stand, it kind of depends on what she says.
right. So it does depend whether a stipulation would be sufficient, would depend on what she says. So I think
One, sure,
I want to make sure.
they're saying it's stop. By way of stipulation that you sort.
Right, but it depends on what she says exactly, I think.
So for now, we're taking them off.
Not necessarily. No, I think that if and when MW denies sending Alon Alexander a text message, then depending on how she denies it, what she says exactly, I can see conceivably a stipulation perhaps would be sufficient, but I don't think anyone is in a position to make that determination now. I think right now, Ms. Snyder is a defense witness.
Judge, I think right now the request should be denied and they can re-raise it if they think that that's necessary. Listing an ASA as a witness is extraordinary. There's really no reason. I mean, this happens all the time where we have conversations with our witnesses. We made the Brady disclosure. If the ASA necessarily then becomes a witness, there are a lot of problems with that.
That's right. Your witness list, we're going to file it more specifically, as well as removing the Snyder offense time. That's your answer.
But maybe, Your Honor, this is more of a question. Can we not just do the inverse and say, at this point, it's not stricken, at least the Ms. Snyder part, until we see exactly how the testimony comes out. And then if it comes out in such a way where a stipulation is appropriate, then that's fine. But that should not be determined now. I mean, nobody knows how she's going to testify. And
Also,
Right, right.
so it's either inconvenience with here or it's inconvenience.
Well, I guess maybe just to confirm that we're all under the understanding that it's possible that if MW denies sending the text, that a stipulation would not be sufficient and we would call Ms. Snyder to the stand.
Judge, right, if she denies sending the text, then I will enter into a stipulation stating that she came in on March 19th, 2025 and told me XYZ, which is what I said in the statement.
If she denies sending the text, there's a stipulation, and you all can submit a written document on the stipulation that she did in fact. Say something along the lines of, what are you up to? What's up?
It's what's up, and then it's LOL is the response is what I was, or something along the lines of is what she said. She couldn't remember the exact words.
Then any stipulation.
I think, Your Honor, the context of the conversation is going to be important depending on how MW answers. So it's hard to kind of.
Based on what Snyder offered regarding what she's able to stipulate to, I think you all have the parameters of how she would be impeached since she testified. This is what she's already done. That and also by the way of discovery sentence. I also have something on my desk regarding order regarding ICLOUD and data filter terms.
Yes, Judge. We are still, as Your Honor knows, we brought Your Honor a warrant for Alon Alexander's iCloud. That has been submitted to Apple. We are waiting on the response, but just to move things along, we are asking that Your Honor enter an order go ahead and direct Mr. Gennaro to send us the filter terms so that we have those and we will implement a team. Yes.
Yes, no, we finally got a copy of the affidavit I had this morning. I haven't had an opportunity to review it. I will tell you that on the filter terms, I know that, and I'm certain, even though I was not the lawyer in 16, there were many other, I'm going to have to give you the filter terms based on attorney-client privilege stuff. However, because my clients are in New York, I have a call set with Alon Thursday of this week. So I know that the state had more than 2 days. I'd ask for some more time to get those filter terms. So I'd ask for, 2 weeks.
Judge, that's going to take us outside of the
10
trial.
days, Judge?
Right, we have a
Just
trial next
same-
week.
I got it, but
And
this-
theoretically, we believe we'll get it back probably.
I'm not-
Based on other responses from Apple, we're hoping this week we'll get it
Right.
back. So we just want to be able to move on it. Ms. Peebles certainly didn't get 2 weeks to get her filter terms together. I know they've already done this in the federal case
Right.
because the federal government has the iCloud and I know that they went through it and there were filter terms. So it shouldn't take him 2 weeks.
I can't,
You some filings. You all give you a bunch of transfers.
Mhm.
We know what's publicly available federally. If the FBI has gone to the iCloud and has the drone video. We know.
No,
That's
Judge.
publicly available.
We don't know. We don't know. No.
Would their discovery be public record, being the US Attorney's discovery?
I don't know, Judge. With that order that they have in their case, I don't think their discovery is public record,
The protective.
protective order. So Judge, right, so
Be seen to the publicly available transfers. We've seen videos, conversations, at least from 2016. That have been extracted from the electronic devices. So my question is, has anyone seen, based on these transcripts of what's been presented in federal court, if the drone video was in the iCloud or somewhere else on Alon Alexander's electronic devices?
Judge, I don't know. We're gonna wait to see it, because I don't know that the feds would necessarily identify that particular video as important, right, to this particular case, because they don't have this case, right? They have, right, so I don't know that they would recognize it. So,
Judge, the thing is there's obviously clients don't have to stand trial next week. So I just want to make sure that I have the time to go through this with my clients who are in New York, and there's never been, I just haven't seen this type of urgency from the state unless it involves us. We've been waiting on extractions for months. Ms. Peebles is given 10 days to object. Ms. Peebles, I believe, is even involved with the painting. I'm not asking for that. What I'm asking for is a couple weeks so that I can make sure that I can produce. And it's not against my client's not on trial, unfortunately, next week. We wish it was. We wish that the supposedly the feds went back on their word to bring him down here. We haven't made a motion to try and abstention, although we very much want a trial now. But Judge, I just need time to just like the state was given time and Ms. Peters was given time. So
I gave her a couple days plus a weekend.
Yeah, I don't even know. I know she got maybe, the order came on a Friday. I think she got to Monday at a certain time. So yes, Judge, I just ask for the same turnaround time so that we have those ready to go.
it's just a little more cumbersome, Your Honor, when your client's in custody, and I have to arrange for phone conversations. They're always booked, and I'm gonna get in with him on Thursday of this week.
You're gonna do your taxes, your support taxes, state in 48 hours. So 11:15 now, you have Wednesday, 11:15 a.m.
To come up
Get
with,
them, to get them.
okay, Judge, but I can't get them in that time, so because I have a call with my client on Thursday, so I would ask till Friday.
And trial is Monday.
They're gonna have the weekend to work then, Judge, if you just give me till Friday.
Fast in 48 hours. And you all will communicate, just like I asked the people to communicate. And I also think I put a similar deadline on the stage that they had gotten. The 19 photographs. I asked you to communicate with the state, so communicate with them. If you
So I'll do that, Judge.
can't speak to them, we're gonna try.
I'm gonna do my best. I'll call the jail, Your Honor, and try to see if they can move up the call, but for now, I'm set to talk to my client Thursday.
So right, here's an order. Right, is there also a motion for you, is this the last motion, the resolution to close schools?
Now, I don't know if Ms. Peebles, I think this was, Ms. Peebles got this or not. She was.
Yeah, I did. I was given the motion to compel, and I was given, I think it was last week or on the 20th, about the extraction issues. I've not seen any motions to redepose me. But I certainly would object to that on the previous grounds that we litigated.
Can I have to deal with this on Wednesday?
Well, Your Honor, the
Can I get the
issue.
date that it was filed so I could at least go check the online docket?
June 19th.
I am fairly certain she was copying. But Your Honor, I would ask not if we could not wait till Wednesday. Clearly, I don't think it's a close call anymore. I mean, I think, Your Honor, at the last time we filed one of these motions, denied it without prejudice pending MW's deposition to see if there was any testimony regarding whether attorney-client privilege was waived. And it happened, right? She confirmed, and I'll point you to just page 11 of the motion. She was asked, did you give Ms. Peebles permission to tell Ms. Snyder about the facts of your case? Answer, yes. Question, yes. Answer, yes. That's that. And I won't even belabor the fact that MW went to Vanity Fair and told her story, that Ms. Peebles, I know Mr. De Niro showed what seems like forever ago, but it was a few months ago in one of the hearings, a video of Ms. Peebles telling the story. So clearly that has been waived. Importantly, Judge, there are things that are not attorney-client privilege that Ms. Peebles can just factually be deposed about. So, like, for example, whether or not there was a retainer agreement and what that retainer agreement is. Just to give you an example, MW in her deposition says there is no retainer agreement, and I'm not kidding, seems to think Ms. Peebles is doing this out of the goodness of her heart and is never going to ask her for a penny. So either MW is lying. We need to figure that out, because clearly they're kind of masking the relationship. And then we have Ms. Peebles coming in, and not only does she initially just to represent MW, but now KW and CW, and it's just, she's the one filtering all the discovery. She's the one, I'll remind the court, actually, this has come out in other motions, but not in the original one because we still hadn't deposed MW. MW said, and it's in this motion, MW said that Miss Peebles is the one who redacted the Uber receipt that we were given in discovery. That's just one piece of it. That's just one example. Ms. Peebles is not just an attorney in this case. I think it is abundantly clear by now that she is basically sitting at the prosecution table. And she's the one that they have to go through to be able to get access to not just MW, but KW, CW, and BC. She's the gatekeeper. So this idea that she's not deposable, that she cannot be deposed because she can just hold up her bar card is honestly, Judge, not how it works.
So, if I grant the motion, she'll make herself available July 5th. Okay?
Perfect.
That is key. So I'll give you until July 2nd to look into it. If I grant it, it looks like it might be on a daily basis, correct?
Just
You
one other,
make yourself available July 3rd.
yeah,
I'm
just,
saying I'm going to, but I'm saying I'm gonna give you time to respond.
just one other thing that I'm not sure is included in the motion. For certain in the deposition, MW says she gave permission to Miss Peebles to recount her story to the state. Court might remember during the interview between MW and Alvarez, Miss Peebles was there with the state, with Alvarez, and she's correcting her client throughout the most of, or at 3 different points during this one statement of Alvarez. So it's waived, and we.
I'm sure you all address, because I haven't done it deep dive, I'm sure you all addressed in this motion. There's case law in the state about defense attorney negotiating a plea on behalf of their client, right? So they are talking on behalf of their client about their position, correct? So that's in this motion.
Well, negotiations.
We've already been down this road with regard to whether or not it's waived. The defense attorney, criminal defense attorney, you all want to negotiate on behalf of Mr. Fisherman. You go talk to Ms. Snyder about that, but this is necessary to waive Fisherman's client's privilege.
Right. I think if the Shelton test, I think the key is Ms. Peebles is not opposing counsel here. She's not, unless, and if she is, then we have to go back a few motions ago, because then that makes her again part of the state. So, she's got to pick.
What is it?
Your Honor, like I said, I will address this in writing, but also our previous motion, that's just incorrect. My client didn't waive any attorney-client privilege. When they're talking about restating facts or alleging facts that relate to a complaint that was filed, that's not a waiver of privilege. As attorneys, we come and talk about our client's position in open court all the time. That doesn't waive anybody's privilege with their client.
So I await a response, I'll take a look at the motion as well as the transcripts, because they cite specific parts of the transcripts where they're saying she waived it.
When she's in the presence of the third party, in this particular case, it would be Alvarez, and the other case, it would be when she was in the presence of Ms. Snyder, when she says that she contacted my client and said, "What's up?" after this alleged incident. So she also gave an interview.
So just to give you all a preview for scheduling, I have a competency hearing that I need to finish on Wednesday. That's one. So we're gonna meet on these 2 motions that are set from today till Wednesday and be together.
Just take out the file motion to Monday. I think that's correction. Or I have not received anything.
And what time was that, Your Honor? I didn't.
2 p.m. on Wednesday.
2 p.m.
And are we also still set for the one, is it all moved to 2 now?
Yeah, I have to remember to sorry, 2 you said or 2:30, I'm sorry.
2.
I think if you're telling me 2:30, I mean, I'm fine either way. Don't worry.
It'll be 2:30, sorry about that. Otherwise, I may just make you all wait down on the. So 2:30 was. 2:30 on Wednesday. You'll probably be together a long time, right? I'm gonna ask, because I have to ask, is there anything else that we need to address for Sue all? No? Sure. Okay, I'll see you all Wednesday. Thank you all.
Thank you, Your Honor.